It is because he discharges these duties that when he makes a determination as the sort that was made, Mr. Sibal is up in arms against that. Because he can challenge it, because it's not administrative, he decides to throw them out and therefore they come challenging it. That is why it can't be purely administrative, is my view. The law doesn't suggest that. If you see the entire duties that he's discharging, these are duties that can cause some kind of upset. Two last things. One, section 66, if you take a look for a minute, and this could be the apprehension, and there is enough reason for this apprehension, because as of today, the ED makes a claim saying 9,564 crores have been siphoned away by Byju's to foreign entities, issues a lookout notice, and the company from 2021 doesn't have financial statements for the last 3 years. Without creditors of the corporate debtor or for any fraudulent purpose. The NCLT may, on the application of the resolution professional, pass an order that any persons who are knowingly parties to the carrying on of the business in such manner shall be liable to make such contributions to the assets of the CD as it may deem fit. 2. On an application made by a resolution professional during the CRP, the adjudicating authority may by an order direct that a director, which is what Riju was, or partner of the corporate debtor, the case may be, shall be liable to make contribution to the assets of the corporate debtor. We have come at the threshold to say, watch out, where is this money coming from? Isn't it our funds which should have been made available to us, my lords? That's all I have to say. I'm grateful.
Yes, Mr. Dewan, anything else that you want to add?
I'll just go point-wise. Can I just remove it? Yes, fine. I'll just go point-wise. Now, point number 1, in the present case, first point, in the present case, there is no written application at all. So there is no written at all. So there is no written application even under Rule 11. Please just note that.
This should have been pointed out in the first instance.
I should perhaps have pointed it out. So, beloveds, I ought to have pointed it out. You are quite right. I'm sorry, my apologies. So here there is nothing under 11. There is nothing through the IRP. There's nothing at all. So my respectful submission is that NCLAT, because it is subject and it is subordinate in the sense there is an appeal to this court, would at a minimum or ought at a minimum to have insisted upon a written application. The manner in which it happened, so nothing under 11, nothing at all. Now, this is a little important because your lordship, because it all functioned on that first undertaking, then the undertaking is not available, we'll do this, we'll do that. And please recall, before 2nd of August, which is the impugned order which came to be passed by NCLAT, the other side had already paid 50 crores.
I noticed that, yes.
I mean, just imagine. So look at the no application. You're virtually, it was a bit of an ambush as far as we were concerned. So you're saying that, oh, we're all down the road, down the street, 50 crores RTGS has been paid, no written application. So I would respectfully submit now, just keeping everything aside, no written application. Number 1. Point number 2. You have a situation where I had pointed out in my opening, and now it's not even contested. In fact, they were very fair to say that the payment was not made within the times of that undertaking, and it was a self-operative order. Then surely, Ballots, consequences must follow. So this is one part. Now the second part, let me just very quickly deal with the authorities very quickly. The Solicitor General's, Mr. Mehta's compilation. So would you just take that up? Your lordships have already pointed out a couple of paragraphs. I'm just supplementing them. Insofar as Abhishek Singh judgment is concerned, your lordships have correctly pointed out paragraph 6. On page 106.
Yes.
Where para 6 itself on facts, the interim resolution professional on 10th March 2021 moved an application under regulation 30 capital A seeking withdrawal of the CIRP against the corporate debtor. Along with the application, the OCs, etc., were made, was also attached, was also moved under section 12A.
Yeah.
So this is a case of an application. And the second point, which your lordships may have noticed, but I just pointed out, in the order which is in Ashok Rajani, just please go to page 102, para 21. There again, there was an application. On 12th August 2021, the parties, with the consent of the IRP, filed an application under Section 12A of the IBC before the NCLT Mumbai. However, the same has not been listed till date. So there was an application, although it was not taken up. So then the whole issue arose in terms of that inherent power. But there was an application. Now we have, just to complete the decision, the judgments, please just take up, there's a compilation which we have furnished. Just get that around this one. Because it's volume 2. I'll just state the point here. This is now on that inherent power question which your lordship said. Sorry, might this be mine? Yes. Volume 2, would your lordship just take up?
Yeah.
It starts with EBIX.
Yeah.
I'll just give you the paragraph.
Yes.
Your lordship has that? EBIX?
Yes.
Correct. So this, now the EBIX judgment, the observations which are relevant for our purposes is paragraph 101. Which I believe should be at page 186. Well, with page 86, I'm sorry. Now I'll just explain. Here the question was in the context of, is there an inherent power to allow withdrawal by a successful resolution applicant? That was the issue. Now please see 101. May I place it? Any claim seeking an exercise of adjudicatory authority's residuary powers under section 65C IBC, NCLT's inherent powers under Rule 11 of the NCLT Rules 2016. Let's pausing here for a moment. Rule 11 of the NCLT rules are in pari materia with Rule 11 of the NCLAT rules. We are concerned with the NCLAT rules. Or even the powers of this court under Article 142 of the Constitution must be closely scrutinized for broader compliance with the insolvency framework and its underlying objective. The adjudicating mechanisms which have been specifically created by the statute have a narrowly defined role in the process and must be circumspect in granting reliefs that may run counter to the timelines and predictability that is central to IBC. Any judicial creation of a procedural or substantive remedy that is not envisaged by the statute would not only violate the principles of separation of power, but also run the risk of altering the delicate coordination that is designated by the IBC framework and have grave implications on the outcome of the CIRP, the economy of the country, and the lives of the workers and other allied parties who are statutorily bound by the impact of a resolution or liquidation of a corporate debtor. So this is some guidance to be obtained over here. And please see para 159 on page 119.
Yes.
IBC is silent on whether a successful resolution applicant can withdraw its resolution plan. However, the statutory framework laid down under the IBC and CIRP regulations provide for a step-by-step procedure, which is to be followed from the initiation of the CIRP to the approval by the adjudicating authority. Regulation 40A describes a model timeline for the CIRP that accounts for every eventuality and may arise between the commencement of the CIRP and approval of the resolution plan by an adjudicating authority, including the different stages for pressing a withdrawal of the CIRP under Section 12A. Even a modification of RFRP is envisaged by the CIRP rules and is subject to a timeline. The absence of any exit routes being stipulated under the statute for a successful resolution applicant is indicative of IBC's prescription of any attempts at withdrawal at its behest. The rule of casus amusus is an established rule of interpretation which provides that an omission in a statute cannot be supplied by judicial construction. So here, of course, we have an express statutory regulation. Now, yes. Now, the second, I'll just complete the decision, because there is another volume, which is volume 1, which I'll just request the court master to hand over. And here there is one decision that I wish to place. Your lordships have volume 1. So I'll just, sorry. So here I want to first just draw attention to the judgment which was just cited by Mr. Sankar Narayan. That's at page 26, Indus Biotech. So it's in this compilation at page 126, 2021 6 SEC 436. And the paragraph he referred to is at page 149, para 26. The determination that it is in rem.
Yes.
Correct? So that's just as a point of information. My learned friend read it.
Yes.
Your Lordship, it's a para 26 at page 149. Correct?
Yes.
Oh, I saw 17 and 26. I believe he read 17. I just placed 26. The underlying principle, therefore, from the above mentioned decisions is that reference to the triggering of a petition under section 7 of the IB Code to consider the same as a proceeding in rem. It is necessary that the adjudicating authority ought to have applied its mind, recorded a finding of default, and admitted the petition. On admission, third-party right is created in all the creditors of the corporate debtors and will have erga omnes effect. The mere filing of the petition and its pendency before admission, therefore, cannot be construed as the triggering of a proceeding in rem. Hence, the admission of a petition for consideration of the corporate insolvency resolution process is the relevant stage which would decide the status and the nature of the pendency of proceedings, and the mere filing cannot be taken as triggering of the insolvency. My learned friend, sorry, I stand corrected. Refer to paragraph 17, 17. Now, Lords, the authority which I just wish to place, the paragraph, in fact, is at page 434. My Palace Mutually Aided Cooperative Society. Now, here what had happened was that a recall order had been passed exercising 151 powers. Your Lordship, sir, page 434. So 2022 SEC Online SC 1063.
Yes.
This was, as I mentioned, 151 power was invoked. Please go to para 26. That's the only para I just seek to place reliance on. Section 151 of the CPC, page 438. Section 151 of the CPC provides for civil courts to invoke their inherent jurisdiction and utilize the same to meet the ends of justice or to prevent abuse of process. Although such a provision is worded broadly, this court has tempered the provision to limit its ambit to only those circumstances where certain procedural gaps exist to ensure that the substantive justice is not obliterated by hyper-technicalities. As far back as 1961, this court in Padam Sen versus UP, AR 61 Supreme Court 218 observed, the inherent power of the court are in addition to the powers specifically conferred on the court by the code. They are complementary to the powers, and therefore it must be held that the court is free to exercise them for the purposes mentioned in section 151 of the code when the exercise of those powers is not in any way in conflict with what has been expressly provided in the code or against the intentions of the legislature. It's also well recognized that the inherent power is not to be exercised in a manner which will be contrary to or different to the procedures expressly provided in the code. And then they go on, therefore, to allow the appeal because this 151 was not correctly exercised.
Mr. Devan.
Yes, I'm sorry.
Come to page 432.
432.
Of course, it's
32.
432.
Yeah, that's the earlier case.
Read para 10, paras 10, 11, and 12.
Yes.
That's the correct understanding.
Yes, I'll just place that. So, Manoj, this is the NCLAT decision.
Correct.
Beginning at 428.
Just 3
Yes.
paragraphs.
I'll read para 10. 432. It is well settled that the inherent power can be exercised only when no other remedy is available to the litigant and nowhere a specific remedy is provided by the statute. If an effective alternative remedy is available, inherent power will not be exercised, especially when the applicant may not have availed of that remedy. It is also settled law that inherent power cannot be invoked which intends to bypass procedure prescribed. The procedure prescribed under the law is to be followed strictly. Rule 11 of the NCLAT rules provides that the inherent power of the appellate tribunal can be exercised to make any order as may be necessary for meeting the ends of justice or to prevent abuse of process of the appellate tribunal. This provision suggests that such power can be exercised in the absence of express provision of the code or regulation. The procedure prescribed for withdrawal of a petition under sections 7, 9 or 10 of the IBC before the constitution of the COC and after constitution of the COC is provided in section 12A and regulation 30A of the regulation. When the settlement has taken place at an appellate stage, the applicant who has filed a petition under 7 or 9 of the IBC may, your lordship's decision. So, my lords, I am now done. I'll just hand over that AR 61 Supreme Court 218. We've just given 3 copies, just because that's the one which was relied upon over here.
Anything else?
Yes. Now I'll just go point-wise. Now the next point I wish to make is with reference, please just note, grievance was made with regard to default. Now I just want to make 2-3 points on that. But before that, fellows, may I, with your permission, just pick up a point which was just mentioned by Mr. Gopal Sankar Narayan just a short while ago. Please note that the last audited accounts of Think and Learn Private Limited are as on, please note this, 31st March 2022. Now there is an extract of this document, and here I request your lordship to take the main appeal paper book, page 166. Please go to 166. The extract itself begins at 164, but just go to the main paper book itself, 166. Yes. Do you have a PDF?
Okay.
Look, it's Annexure A5. I'll just go point-wise. Annexure A5.
The main side.
Do you have A5?
Yes.
Now this is 164, begins at printed page.
Yes.
Yes. Please go to 166. You will find a figure towards the end of that block. Total comprehensive loss for the year. 8,104.68 crores. Your lordship has that? Now this is 31st March 22. This is the only document which they have filed. 31st March 22, 8,104.68 crores. And as on 2021, the total comprehensive loss for the year was 4,588.75 crores. So it had doubled. Now, one of the reasons for default was, just please note it, that they were obliged to keep supplying us for financial transparency the documents which they were not supplying. That was a default in terms of the lender's agreement. I'm not giving you. But this figure of 8,000 crores is very, very important. So it's not as if we have triggered something which has resulted in X or Y or Z. Your lordships have seen that figure, 8,104.68 crores. Correct? That's the total comprehensive loss for the year ended 31st March 22. Now please go directly in IA 176578, page 619.
Yeah.
Oh no, yeah. Auditor certificate here. Auditor certificate. 176. Just a minute. 619. Yes. I think that's 619. No, auditor signature. Auditor. Give me a minute. I'm sorry, because my note is 619 auditor. Yeah. Well, it's my mistake. Same document. Yes, my mistake. Millers, it's my mistake. My note was inaccurate. Please just go to page 235.
Yeah, in additional ID. 518?
Millers, which is the one your lordship has? I'm sorry.
176578.
1765. Okay, now that your lordship has it, then let me complete with that. Because a slightly different point, but I'll just complete with that. Now, please just go to page Annexure A35.
Of what? The main paper book?
No, same.
Additionals.
A35, the same.
Seven.
Do you have an A35 Manoj? 709?
A35,
A35,
Form-
709.
Form D,
Form D.
record of default.
Yes. So now just let me pause here for a moment. Under the regulations, before Section 7 is filed, we have an information utility. Before the information utility, you load your claim. The information utility sends them notice, first reminder, second reminder. That's all provided in the regulations. If they do not contest the claim, the default is certified by the information utility. Information utility is a statutory concept under the IBC. So therefore, you have record of default. Now, this record of default is issued therefore by National E-Governance Services Limited. This record of default is issued to the financial creditors group represented by the Catalyst trusteeship, etc. It's in respect of Think and Learn. Now, this figure which your lordships will find, which is quite in G, is in US dollars. So we submitted on 2nd January 2024, deemed to be authenticated. And authentication completed on 18th January 2024. So this document accompanies and is part of my Section 7 application. Now, just note the regulation, because there's a regulation covering exactly this. Authentication of default is mentioned and covered under Regulation 21. You have it. The name of the, I've got a copy, I'll just hand it over. Just give it. It's called the IBBI.
Why don't you do this? You can give us a one-page
Okay.
note on this. So that
I'll
we can
give
put
it, but
on a
just
page.
note the point.
Yeah, just
So IBBI regulations provide for this. There are regulations of 2017, and basically it provides that it is deemed to be authenticated if the debtor does not respond even after 3 reminders. That's the regulation itself. So this comes to be issued, and this therefore is now part of my Section 7. This is my first point. Now let me complete this point. The second point is, since they said that there was an accelerated default argument was rejected in Chancery in Delaware, and it was rejected by the Delaware Supreme Court, expressly rejected. This was their point, that there's no default. So the Delaware Supreme Court has affirmed it. I pointed that judgment out. Now, as a counterblast to the Delaware proceedings, Think and Learn instituted proceedings in the New York court, which my learned friend mentioned to you. In the New York court, because this issue is now concluded, there is a concept of issue estoppel, which they call collateral estoppel. In Black's law, the ground there, they call it collateral estoppel, because the collateral proceeding, the estoppel has taken place. So we have moved for dismissal, because they got no interim order in New York. We have moved for dismissal of their claim on the ground inter alia of collateral estoppel, where judgment is reserved. So default, issue of default, defense of default, raised all the way up to the Delaware Supreme Court, rejected on their part.
we do this by
Yeah.
the end of the day today, just
Yeah.
on one page. Just give us a one-page note so that you know that we don't.
Very well, correct. So now this is, yes. So Manoj, now this is my point with regard to the question of default. The whole
Don't make it a very prolix.
Okay, we won't make it.
The pages and the points.
I appreciate that.
We have taken it down, but
Yes.
we shouldn't miss
Yes.
it.
Now, please just go to the IA 207399.
What is the point there?
Yes, the point there is, it actually ties, sorry. I'll just state the point. I'll just state the point. The point is, and this should create alarm to almost everybody apart from not filing audited statements. This is subsequent to your Lordship's interim order. 3rd September 24, their statutory auditor has put in his papers. And I want your Lordships to see that, page 235. Page 235, annexure A25, the reasons he has given, IA 207399. A25 at page 235. Subject, your Lordship has that?
Yes.
Resignation as statutory auditors of Think and Learn, the company from financial year 22-23. Now please see para 2. The following specific facts and circumstances have compelled us to resign as the statutory auditors of the company. The financial statements for the year ended 31st March 23 are long delayed. Then he goes on. Now see subpara B. Inadequate details and explanations regarding the company's inability to recover the dues from so-and-so. We had requested for a more detailed forensic review, etc. There have been inordinate delay on the part of the management to initiate forensic review despite our repeated reminders sent via various emails. Most important for our purposes is F. I'd like you to just see F on page 236. I'll read it. We have requested the management to provide us an audit trail and confirmation in respect of US dollars 533 million, which were part of the borrowed funds from lenders primarily represented by Glass Trust Company LLC, as were available to the group for investing outside India. This information is required for the purpose of audit of consolidated financial statements. Since the company has lost control over certain of its subsidiaries, the management has been unable to provide us sufficient appropriate evidence in respect of these funds despite repeated reminders. Now, this is as recently as 3rd September 2024. So what you have is a fairly, in our respectful submission, alarming situation, which your Lordships have noted. Now, my Lords, I go to my next point. The point which we made with regard to, and this is a little important because the brothers seem to have similar names. The point which we made was that as far as the media reports are concerned, please note, this is a little important because he says he's produced those passports, etc. The media reports, because I don't know, are of February 2024, only specific to Mr. Baiju. The amount in excess is in excess of 9,000 crores. And the only point I'm making at this stage is that the media reports in 3 respectable journals say, or media outlets say, that this is 9,000 crores. As far as Baiju is concerned, there is a lookout notice. I put it no further than that. That's the basis on which we went and we mentioned it. The ED, yes. Now, my Lords, I've already made my point regarding the point is not really on that undertaking, apart from the RTGS not being made on time. See, the arithmetic point which we made is not qua them. In their minds, they may have many whirring explanations. The question is NCLAT. How does NCLAT allow this kind of an undertaking to be accepted and to accept it? And now that we have the advantage of the certificate, which the auditor's resignation letter, I'm pretty sure that even someone like BCCI is certainly, as a public authority, is not going to say, once the statutory auditor has put in his papers and said, sorry, no explanations coming regarding the tracking and the tracing of these funds insofar as management is concerned. I'm sure BCCI is also not going to touch this money because who knows where this will end. So anyway, that's a separate point. Now, my Lords, I just want to mention on the TRO, on the temporary restraint order. Now, on the temporary restraint order, I would like your Lordships to just have a look at there are 2 specific documents here, and you will get them from the BCCI reply itself. Please take up BCCI's reply.
Mr. Diwan, it's not necessary for us to go into all.
All right, but I'll just mention to you, so I'll just state the point. The language used is Mr. Ravindran's use of perpetuate personal assets. So in the letter to BCCI and in the filing which we made, which we were not successful in obtaining because they said the appropriate forum is India. So forum non-convenience, the expression which we have used is perpetuate personal assets. So we've not given up the case with regard to whether this money is from.
Down in your notes.
I'll put it down.
One page, don't make it.
I'm very grateful.
Thank you, Mr. Diwan.
Yeah, very good.
Not more than a page, but give it by the end of the day, so we
Yes,
are fresh.
not more than 5 minutes.
Yes, Mr. Diwan.
Well, let's kindly come, just apropos what my learned friend said, kindly come to page 749 of the reply of the second respondent in the civil appeal 9986. Page 749. This is the minutes of the meeting of the first COC, Malat, which was not provided to us but given to the BCCI. That's how we got it.
That's 1.1. Your appeal is 1.1.
Yes, Malat. Yes, Malat. My concern is about the conduct of the present IRP, but be that as it may, I just want to show something. Replies in the civil appeal, Malat. It's 749. Your Lordship has it.
Additional. 317.
It's Roman 5 at page 749. Request of it for information meeting and IT access. Come to the next slide.
Take picture of that.
31099. Printed page on top.
Printed page is 749.
We got 749. Yeah, 749.
What's it? Got it, Manas?
Got it.
My Lord has it?
Yes.
Now, may I just read Roman 5, Manas? This is the first meeting of the COC. The interim resolution professional informed the committee of creditors that multiple requests have been made to the suspended members of the board.
Sorry, where are you reading?
749 is not there.
It's not there.
It's printed page 749, right?
749, Malas.
Then it begins with section 10.19.
No.
Starts at 7:45. 7:45.
It starts at 7:45 at 7:49.
490.
499.
The reply by BCCI,
Second respondent.
who is the second respondent.
Ah, yes.
Yeah, that's it.
Lordship has it now? I'm sorry, Malas.
No problem. 4997.
Yes. The interim resolution professional informed the committee of creditors that multiple requests have been made to the suspended members of the board seeking essential documentation and details regarding the assets, financial status, and operations of the corporate debtor. These requests also included a formal proposal to schedule an in-person meeting at the corporate debtors registered office to facilitate effective communication and a comprehensive understanding of the current situation. Additionally, the IRP emphasized the need for unhindered access to the corporate debtors' IT resources and the protection of IT data to prevent any unauthorized deletion or modification. Despite these requests, no information or cooperation has been received from the relevant parties to date. The lack of response continues to hinder the progress of the corporate insolvency resolution process. This is the conduct of the party members, of the corporate debtor. That's number one. Now, the conduct of the IRP, just for the moment, before I go into any document, look at the code, what it says.
But, on the removal of the IRP, we're not in.
I'm not on removal, Manas. I just give me a minute, Manas. Just give me a minute. We'll see the Insolvency and Bankruptcy Board of India Insolvency Professionals Regulation 216. What it says. It's his duty to abide by the code of conduct specified in the first schedule to these regulations. Right? And the first schedule is just 2 pages, only 2 pages. Normally it says An insolvency professional must maintain integrity by being honest, straightforward, forthright in all professional relationships. 2, an insolvency professional must not misrepresent any facts or situation and should refrain from being involved in any action that would bring disrepute to the professional. 3, insolvency professional must act with objectivity. He has thrown us out, Malaj, on the
holding a meeting today at 4 p.m. until 99% to 100%.
Malaj, on the 2nd of after I filed for his removal on the 2nd of September, I take an inspection. The record shows I'm 99.41% on 2nd of September. On the 3rd of September, Malaj, he removes me in the morning.
Because a COC, you can remove him.
Because he's COC, I can be removed.
Right.
COC, we can remove him. But he removes me and makes the 0.18% 100%. And that he's holding a meeting today at 4 o'clock. And Malaj, one of his responsibilities is an insolvency professional must adhere to the time limits prescribed in the code. What's the time limit under 22(1)? That he 7 days. Ex facia he has not done. Then he adjourns it to Malaj 3 times on the 30th. Then he adjourns it to the 3rd, and 3rd he passes this order and says that I am not a. After having on 2nd September, I took an inspection, and that is on record, Malaj. I placed it on record. And Malaj, he falsifies an email.
The third, the meeting is to happen at 7. He holds it at 10 o'clock. Just
On 2nd September, I have taken an inspection. That's at page 133 of my paper book, of SLP paper book. On 2nd September. And the record shows I'm 99.41%. And the disqualification letter is an adjudication.
he said
That-
after I filed.
He sends it after I filed for his removal. I am telling him that I am mentioning the matter in the morning. Because the COC meeting is at 7 in the evening, he prepones it at 10 o'clock in the morning.
Council makes a statement that
And in the council then makes a statement that it's all over now. I've been thrown out. I cannot be a member of the COC. And that's the other thing, that he doesn't have any adjudicatory functions, Malaj. He says, I have a contingent claim, Malaj. He has no adjudicatory functions. The other side even argued it. My learned friend, Malaj, on the other side said he has only administrative functions.
he's calling me the professional director for the meeting, but not a
He is calling him Malaj operational creditors for the meeting, but not a financial creditor. Well, this is very, very serious.
He's lodged a complaint with the IBPI, no action in that.
We also lodged a complaint with the IBBI, no action. And Malaj, when I go to the NCLAT, right?
Yeah.
The NCLT, BCCI comes and says, make us a party. Malaj, how is BCCI so concerned with all this?
Whose role ends after.
He says, you can't hear him till you make me a party. So, Malaj, this is, and now he is holding a meeting at 4 o'clock today, knowing full well that the matter is pending here. So, Malaj, my respectful submission to your lordships is, there must be a complete status quo on all this, right, Malaj? He should not be allowed to function till all these matters are decided.
Yes.
Malaj, I'm sorry, just 2 quick things which are consequential. One is your 14th August 24 order.
Just one more thing.
Sorry.
Well, it's just one more thing and then I'm done.
Proceedings are never used as.
Well, these proceedings in law can never be used as recovery proceedings. Your lordships have said not once but several times in judgments of the court. This is a recovery proceeding. This is a resolution, Malaj's plan that has to be put in place. Right? And Malaj, if there is an inherent power to be used, it has to be used along with the 12-day. It can't be used independently of that. That's all.
So just consequential.
Inherently insolvent.
And para 28 of Swiss ribbon says exactly that.
Because your 14th August 24 order, your lordships in para 4 had said that 158 crores would be kept in escrow by BCCI pending further orders. I'm saying that 158 should now be transferred back, which the IRP will monitor under section 17. He will have to monitor and do whatever is necessary. IRP, RP, whatever, subject to whatever your lordship decide on the RP aspect. The second is, I believe, there's really nothing to remand as far as that main matter which Mr. Devan also argued. There was no application, there was nothing, it was an exercise of a power which didn't exist.
Excuse
Yes. Close it now.
Your Lordship, on the simple SLP, your Lordships are indicated at the very opening that your Lordships are not examining the SLP at the moment because he has arrayed me as a party. I am the RP. So these allegations, no notice has been issued. Your Lordships indicated at the very first instance that the order that has been passed that you've come against, you have not even challenged the constitution or reconstitution of the COC. The NCLT gave you the opportunity to file an application. That has not been done, but you've come straight away here. So therefore, my lord, in the SLP, at the page your lordship will see 48 of the SLP, that liberty is granted. The matter was adjourned to 11th of September. Because the matter was pending before your lordships, the matter has been adjourned by the NCLT. So, my lords, my respectful submission, if in the first instance, the BCCI and, my lords, the others, BIJUs, have to follow the drill, as your lordship said, of the NCLT, the disciplines, here also, my lord, Mr. Sibbal's clients will have to follow the drill, move the NCLT for appropriate applications, so that I have my say. All that is being said to your lordships is ex parte at the present. That is not correct. So therefore,
All the documents are all there.
Lords, just one request, my lords. Claim was not filed.
No.
My lords, may I only. He's an unacceptable financial creditor. My lords, may I only make one submission as far as Mr.
And also, he must not hold the meeting at 4 o'clock today.
Because
that has to be, your lordships must ask them not to hold a meeting. He's holding a COC meeting. He's holding a COC meeting today at 4 o'clock. He must not hold it. Till such time your lordship renders an order.
The arguments have been concluded.
May I only make one submission as far as
judgment is reserved. Stop. Until the judgment is declared, until the judgment is delivered, is pronounced, the interim resolution professional shall maintain the status quo and shall not hold any meeting of the committee of creditors.
In fact, we have said that even if your lordships, although we are opposing it, it should be remanded back. Even in that case, a COC should not be constituted till we avail of our entry. Because it will really be a backdoor entry again for the same party into the COC, who claims that it has 99%.
Enough has been said for us.
You want just one page note on facts, because by then we were flagging a little bit in energy. We made some notes, but we don't want to miss something.
Can we both file our brief?
Or we just rejoined just that one little page.
Rebut that at least, because that's
Chat at 2 p.m.
Come back. Mr. Venkataman, we'll come back at 2 o'clock and start jet.
So, your lordships have used the word IRP, RP.
RP. Resolution.
Challenging his status as IRP. It's IRP, not RP. You are
With your lordship's leave, may I make a mention for the special bench matter before my Lord Justice Pardiwala and Justice Mishra, my lord?
So the way
Yes, my lord.
it will not be possible for us to assemble today,
Lordship pleases.
but on Monday.
Monday, my lord.
Monday, we may be in a combination of
Lordship,
myself, Brother Justice Mishra. So we'll,
Monday we are in.
Monday, Mr. Attorney General, Monday.
Then I have to change my travel plans on Monday. I'm out on Monday in Bangalore for a partnered matter. So is it possible on Tuesday, Thursday, Wednesday, any time convenient? I'm sorry for this extreme inconvenience being caused to the court.
It's all right. Tuesday, 3:30.
Tuesday, 3:30.
3:30, we'll try to finish off a little early.
Very well. I'm grateful to your lordship.
We have to just hear you now for about
Yes.
half an hour.
Yes.
And I have prepared a reply to the Attorney General's argument.
Okay.
I'll do that.
Okay. So
That
Tuesday.
I'll give the particulars, my lords, the matter that I'm mentioning.
Grateful to your lordship.
I'm grateful to your lordships, my lords.
May it please your lordships. But before we open up, my lords may note a few numbers, because that's of importance.
My lords, before my friend starts, before my friend starts, I have one small submission. This matter was brought up for your lordships on the claim that there has been a misinterpretation of your lordship's order of 18th January. If that misinterpretation has not taken place, we believe there should be no further indulgence because we are losing crores on a daily basis, my lords. We have extended the bank guarantee as we have promised your lordships, but we're losing crores on a continuous basis. There are ad item findings and no question of law, substantial question of law is made out. It's only the fact that there's a misinterpretation of the order.
All right,
I'm just stating that up.
My friend is defining what we should do. We will do what is best to the court, my lord. Please, therefore, my lord, please note the numbers. This is very important. My lord, the assumption by my friend that it is a case confined to 150 crores is wrong. Please note, my lord, one is relating to the bank guarantee of yes. One item is performance bank guarantee of 150 crores. Two, my lord, an attendant infraction, non-execution of a mortgage worth 300 crores.
Dubai property.
Dubai property, 3 properties, now complete default. Even after the extension by NCLAT is default. My friend can't short circuit and say one bank guarantee. All one. So it's an attendant, it's a connected issue. This will be the first issue which we will pitch. Two, my lord, airport dues to the extent of 475 crores to be paid upfront.
How much you said?
475 crores airport dues to be paid upfront. Restricted to 25 crores.
What do you mean by restricted to 25?
NCLAT says 25 crores. It's a bolt from the blue. Will plain, simple reading of the resolution plan demonstrate it is 475 crores. We will not have to struggle at all.
Second the plea.
Mr. Shankar Narayan, no running commentary. Request. Thank you.
I will say
But 3. Workman's dues.
4.
Workman's dues, according to this, as upheld by this court, is 289 crores. Order deals with 12 crores and totally silent on the balance. So if we add up these three numbers, it comes to, my lord. Yes, my lord, if we add up these three numbers, in terms of monetary limits, it is 914 crores.
Which three numbers?
My lord, for 150, 475, 289.
150, 475 and 289.
If you add it, it comes to 914 crores to be paid upfront, and we are 4 years behind to be paid upfront.
914 crores.
14 plus, my lord, mortgage of properties worth 300 crores. And, my lord, please note two more numbers.
Sorry,
Sorry.
914 crores to be paid upfront. 4 years behind.
We have 4 years, and plus non-execution of mortgage.
That's your point number 2.
Oh, to the value is 300 crores.
You have to add 300 to 900.
Because there is a value for any release of the PBG. The so-called PBG gets released only on a simultaneous execution of this mortgage. That's the condition in the resolution plan. And two more numbers your lordship may kindly note. My lord, the total dues are in the range of 7,500 crores. And the resolution plan, my lord, pegged it at 4,783 crores.
What?
4,783 crores to be paid in 5 years. And, my lord, we are struggling to get the first tranche payment of 350 crores, which expired 180 days from the resolution plan. First tranche of 350 crores, we are still yet to collect that money. When the resolution plan pegs it at 180 days from the effective date. And the last number, my lord, for no fault of us, lenders are incurring 22 crores every month on maintaining the corporate debtor. So it's not just, and see, my lord, the infractions, one after the other. Yes. Only the first issue will take little time. The rest of them will be a lot simple, plain reading of the resolution plan. You don't have to show anything else. I assure this court. We will take the first issue because it came before your lordships and see the infractions they have done. But will your lordship be kind enough? We have a convenience compilation which you have filed it in your lordship's court. But please come to PDF page 186. Oh, it's a SLP paper book. Sorry, I'm sorry. Appeal paper book. Appeal paper book.
For the convenience compilation.
Yes.
In the main diary?
Yeah.
PDF page is 186.
Separately you will do.
Yes, Annexure 1, printed page is 160, PDF page is 186. Lord, this is request for resolution plan. And Lord, please come to clause at next page, PDF page 187. 3 clauses, my lord.
One printed page?
Printed page 161.
161.
Printed page. PDF page is 187.
Doesn't tell you. Right, doesn't tell you. It doesn't tell.
Printed page
Your lord, having the main paper book?
Yes, your convenience compile.
No, my lord may take our main SLP book.
Oh, you are referring to the paper book. Okay.
Yeah, main SLP book itself. I'm sorry. I'm extremely sorry. Lordship may go to the SLP. Civil appeal. Civil appeals.
That is
5023.
Yes, now we got it. RFRP, request for resolution plan.
Correct. I'm so sorry, my lord. I stand corrected.
No problem.
There, 186 is, my lord, the request for resolution plan.
Okay.
I'm sorry. But the first clause is, which we are referring is 187, printed page 161, 3.13.1. My lord, I don't have to read the whole paragraph. Your lordship can take it because it's an undisputed number. 150 crores is towards PBG. Your lordship will get it in bold numbers. Performance bank guarantee of 150 crores. This is to only convey that. I don't have to read the whole paragraph. Then my lords may come to 189 PDF 3.13.7. SBI, in its capacity as an agent of the COC and acting on behalf of the company, shall have the right to invoke the performance security on behalf of the COC, and upon receiving approval from the COC, by issuance of a written demand to the bank to invoke the performance security provided as PPG. The performance security can be invoked and appropriated at any time upon occurrence of any of the following conditions without any reference to the resolution applicant. Without any reference to the resolution applicant, please come to subclause 3, which is relevant for today. Failure of the successful resolution applicant to implement the approved resolution plan to the satisfaction of COC and in accordance with the terms of the approved resolution plan. This is exactly where we stand today. Third clause, my lord, is 3.13.9. The performance security, well, this is very critical because not addressed. The performance security shall not be set off against or used as part of the consideration that the successful resolution applicant proposes to offer in relation to the company, even if expressly indicated as such by the successful resolution applicant in the successful resolution plan. No set off, even if they specify. And these three conditions are now part of the resolution plan. I'm going to show that clause in a minute's time.
Sorry for the interruption. Would your lordship not see, my lord, what is the context of this appeal?
Lord, will your lordship,
context, my lord, is the context a resolution plan? Plan was accepted 4 years ago.
Lord, it's a complete
what is the context?
default.
How does it arise?
Frankly, when
How does it arise? How does the lordship's order arise?
him to tell us how it arose,
Yeah.
but then I said, let him indicate.
Yes,
These are concurrent findings in relation to interlocutory order.
Lord, it's a case
And your lordship's order,
Lord,
all that we have to
let
see.
them say anything. It's a case of gross abuse of IBC process. Lord, we have.
Can that be a
Grinding
ground
point is
without only interlocutory appeal?
Before things become metal scrap.
Right.
Yes.
We just pause, fair enough. Without dislocating your arguments, we won't don't lose track of your arguments. Just in 2 minutes, in a nutshell, tell us how our earlier order came into being, and now what happened thereafter. Just we won't take it down, but just tell us broadly how this arrived.
What are the issues, so that your lordship will know?
No, don't tell us the issues. How did the earlier matter come up before us, and where do we stand today? We remanded it back to the NCLAT.
Yes.
Just tell us an overview.
For a recap.
Just for a refresher into a minute or two.
Give me 1 minute of this question.
No. We'll
After, my friend, 1 minute of this question. How it happened? I will not take more than 1 minute.
Let him argue.
So, my lord, the context will be clear.
I just want to
But I felt there's some substance in that. Just tell us as a refresher how the matter arose last time and how it comes
Yes,
here.
my lord, we'll put it this way. Well, we'll start from here. Lord, the resolution plan obligated a first tranche payment of 350 crores
Right.
and issued an effective date in 5 columns to say this first tranche of 350 and the simultaneous execution of mortgage of 300 crores of Dubai properties.
How did it arise before us on the earlier occasion?
On an earlier occasion, the NCLAT, without going into the Dubai properties and the mortgage, well, they paid us 200 crores as a first tranche payment in cash. After 2 extensions by the 1 minute, Mr. After 2 extensions by the NCLAT. And my lord, finally, the NCLAT said, you have paid 200. You have executed a PBG for 150 crores. Adjust it and make it as a first tranche payment of 350 crores.
I remember.
This is how. So, my lord, without any underlying security,
So what had NCLAT eventually, bottom line, what did they hold on the last occasion?
Last occasion, they said your cash payment of 200 crores is sufficient. Your PBG of 150 can be now removed and put it as part of the first tranche payment and go into the nucleus.
And therefore, in that sense, they were held to be compliant.
Complied and no underlying security.
Right. You
So
came here.
Your Lordship came here.
We set aside the order of NCLAT.
Yes, for two reasons. Now, why we
And
came?
then we said that they must deposit 150 crores.
In Lordship said they should deposit 150 crores and they within 2 weeks. Well, three timelines are very, very important. On 18th January,
they're not taking down anything.
No, I'm just briefing in a very. On 18th January, this court disposed of the SLP, the civil appeal, saying, please deposit within 2 weeks so that you can go and be heard on merits. And also said simultaneously, keep the bank guarantee alive. Two things your Lordship said. 25 para 1 said pay 150 crores. 25 para 2, keep the bank guarantee alive. And let all consequential findings happen before the NCLAT. If you fail to pay 150 crores, consequences under the resolution plan should follow.
All right. Now, what was pending before the NCLAT?
Now, all other issues, but this 150 was one issue.
No, but what is the nature of the appeal which was pending?
Now,
before
default of the condition precedents. There are 4 issues which are pending. In addition, totally 5. One is the PBG of 150 crores. Second is,
what had arisen before NCLAT?
NCLAT, a resolution plan was approved.
Right.
And the NCLT held in its resolution order, subsequent order saying, all condition precedents required for the resolution plan, which are 5 in number, as stands compliant. NCLT.
Right.
We were on an appeal to NCLAT to say none of the 5 conditions stand compliant. For example,
NCLAT had passed an interim order.
Originally, because we filed an affidavit, we said.
No, 1 second.
Yes.
NCLAT had passed an interim order saying that for the first tranche of 350 crores, they had paid 200, 150 adjust the bank guarantee.
Yes.
Right. And your appeal before NCLAT was pending against an NCLT order holding that they were compliant.
They were compliant, which we contested.
So we said that so long as they pay that additional 150 crores, all issues will be dealt with in the appeal.
Yes.
Now tell us one thing. Suppose they were not to comply with our order of 150 crores.
Yes.
We said that the consequences under the resolution plan
will follow. Along with, there's one more layer to it. We thought at least let us start somewhere. Let us allow this plan to work. So we ventured with an.
Can they? We're just exploring it. We'll of course go into the nitty-gritty. Can they contend that though we have admittedly not complied with the Supreme Court order, they also can't dispute the fact that they have not complied with the Supreme Court order?
Yeah.
Can they say that notwithstanding the fact that we have not complied with the Supreme Court order, yet we are entitled to have the appeal filed by you to be heard of?
It
is not their appeal, it's your appeal.
Now we'll answer it in 2 parts. That's their case, which is addressed in NCLAT.
Or is it that the moment they fail to comply with our order, that your appeal has to be ipso facto allowed?
May I answer that?
Yes.
Now there is a layer to it. What we did, this interim order came to be passed for one more reason. We wanted somewhere to start.
Right.
Because nothing was happening. So we volunteered and filed an affidavit saying that if you pay 350 crores, if you infuse, your Lordship has interpreted the expression in our affidavit, infuse. If you infuse 350.
I remember there was an offer by you.
Yes.
So we said in our judgment that once you had made the offer, there could be no change in the terms of the offer.
Problem.
They had accepted.
It's accepted it. So
therefore they had to pay 350 crores.
So we said your Lordship interpreted infuse can only mean a cash deposit.
Right.
It can't be some adjustment. So we said if you infuse 350 crores, we are ready to not give up our claim on condition precedents. That was one of the terms. We'll say we will not press this condition.
Just hold it at this point. Assuming that what was the deal in sense, the commercial bargain between both the sides was this. If they pay 350 crores, if they infuse 350 crores, then you will not insist on the condition precedent.
Subject to only condition precedent, all other conditions are resolution plan.
Fair enough. Now, therefore, their non-compliance of the requirement of 350 crores shows that they have failed to abide by the bargain which you had accepted.
Correct.
Therefore, they are restored to the position in the absence of the concession which you gave them.
No problem. No problem.
Are we right on
Absolutely.
That's what I wanted to say. Nothing more.
Very good. So, my lord, I don't want to disagree everywhere. So, but this is not going to take him anywhere.
Really speaking, then, your appeal stands restored to the point where you seek to challenge the order of the NCLT.
Correct. Now, there is one layer which your lordship has to observe. Now, what we are saying today is, not it is their case. Look here.
By the way, what these observations are not final observations.
Yes,
we are just exploring it.
Therefore, Lord, it's our duty to assist the court. When your lordships passed the 18th January order, will your lordship see only those 3 passages in the order? Only that. So that
we'll also have a little reflection.
Yes, yes.
Things are coming back to us because we are dictated in the open court, I remember.
Yes. It was dictated in open court, my lord. Please, my lord, the judgment starts at page 817 of the same paper book. PDF page, my lord, 843. And my lord, we will read 2 paragraphs in addition to 25, which will make the background clear. 23.
843.
Well, 843 it starts, a PDF page 20. Okay, yes. And my lord, will your lordship be kind enough to come to PDF page 854, para 20? That's 5 paragraphs. That's the crux of the first issue, which we can resolve.
Para 20.
Para 20. 20 to 25. This 3 pages alone. May I read that one?
854.
854.
My friend read para 10.
Para 10. I'll read para 10.
3 appeals. There were 3 appeals.
Yes.
Para 10, my lord, sets out the core.
Yes. I'll read para 10.
What the Chief Justice said 2 minutes ago, that's here.
Yes. I'll read para 10.
Thank you.
Absolutely no problem. May I read, my lord? It's at a PDF page 849. Yes. In an effort to resolve the imbroglio, on 16th August 2023, an affidavit was filed on behalf of SBI by its chief manager. The affidavit stated that the lenders were agreeable to a certain course of action. In other words, the lenders had agreed that if SRA satisfies particular criteria, including infusing 350 crores by 35th August, adhering to the resolution plan terms and meeting employee payment obligations, in accordance with the NCLAT order dated 21st October 2022, they would abstain from challenging exclusion or extension of time issues. However, the liability to meet these conditions necessitates directing the corporate debtor into liquidation as stipulated in paragraph 8A to C. Paragraph 8 is reproduced, but the affidavit is very important. In the present appeal, the lenders are agreeable that in case A, SRA infuses 350 crores by 31/8/2023, the date by which said payment is to be made as per the resolution plan, read with order dated 26/5/2023, passed by the Honorable Tribunal. B. SRA undertakes to scrupulously follow the other terms and conditions of the resolution plan. That is one of the part of the affidavit. C. SRA complies with the liabilities relating to the payment of the employees as per the order of the NCLAT, which has been upheld by the Honorable Supreme Court in its order dated 31/2023. 3 conditions we put. The lenders would not contest the issues relating to granting of exclusion or extension of time in terms of the orders dated 13/1/2023 passed by the NCLT and order dated 26/5/2023 passed by this Honorable Tribunal, as well as on the issue relating to compliance of the condition precedents by the SRA. And accordingly, undertakes to withdraw the present company appeal 129/130, which is pending in adjudication before this Honorable Tribunal, along with civil appeals 4131 to 4134 of 2023 and 3736 37 2023 filed before the Honorable Supreme Court on the said two issues. In other words, lenders would not contest the granting of exclusion as well as the issue regarding the compliance of condition precedents in case the aforesaid steps are taken by the SRA without any further delay. Failing to comply with the conditions mentioned in para A to C above, the corporate debtor should be directed to go into liquidation. Now, this is the whole set. Therefore, it's in 4 parts. It is not just 150 crores as my friends keep on saying. That is infusing 150 crores in cash. B, complying with every other condition of the resolution plan and workman's compensation. Then, my lord, we are ready to give up these 2 appeals or else go to liquidation. Lord, this is the package. Now, my lord, please see. Now, my lord, we can directly come to para 19, if your lordship pleases, so that we save time. Should I read any of them? We can go to 19?
No, that's fine.
Right. Okay, we'll go to 19 now.
Yes.
19, my lord, is PDF page 854. 854. PDF page.
Yes.
While considering the rival submissions, it must be noted at the outset that the appeal stemming from the NCLT January 13th order holding that SRA is compliant with the condition precedent is pending before NCLAT. Hence, the observations in the present judgment are confined to the arrangement which must operate during the pendency of the appeal without this court expressing a final view on the merits of the appeal, which will fall for consideration before NCLAT, which now has fallen into consideration. And my lord, today they don't have an airworthy certificate, they don't have an airport clearance, they don't have a flight clearance, they have not paid the dues, everything is defaulted, every condition is defaulted. And now they say it's 150 crores, 150 crores, completely camouflaging the whole, and everything has been waived. It's a great respect, concurrent finding, but not perversity. We can always come to your lordship. When the resolution plan says 475 crores, how does it become 25 crores? Is what we're going to show to your lordship. Alarming, quite alarming, quite alarming. So, Lord, 90
is the
1
scope.
minute, Mr. Rogtiki. Either you should come to my side and argue or allow me to argue. Thank you. Please, not come to para 20.
Yes.
The occasion for an extension of time to the SRA for the deposit of 350 crores as a consequence of the affidavit which was filed by SBI before the NCLAT on 16th August. SBI's affidavit envisaged that the lenders would not contest the issues pertaining to A, the grant of exclusion of time, B, extension in terms of the orders which passed by NCLAT and so, and C, compliance with the condition precedent by the SRA. SBI's offer was, however, subject to fulfillment of the 3 conditions. Then, my lord, please come to 21. Conditional on compliance with the 3 conditions set out above, SBI stated that it would be willing to withdraw both the company's appeal, which were pending before the NCLAT, as well as the civil appeals which were pending before this court, details of which were set out in the affidavit. The offer which was made by SBI on behalf of the lenders had to be complied with as it stood in the event that SRA sought the benefit of the offer. According to the SRA, the PBG was liable to be released on adjustment in terms of the resolution plan. This is a matter which should have to await an adjudication by NCLAT in the pending appeal. The impugned order of the NCLAT, on the other hand, allowed the plea of the SRA for adjustment and consequential release of the PBG at the interlocutory stage. This prima facie would not in accordance with the tenor of para 8 of the affidavit which was filed by SBI, in which it stated that the lenders would not contest the issues in the pending appeal conditional on the compliance with 3 conditions which were set out in the affidavit. Infusion of rupees 350 crores as envisaged in the affidavit could not have been substituted with a direction for adjustment of PBG at that stage. Infusion meant that the 3rd tranche has to be paid in the same manner. Adjustment of PBG was not permissible. In the circumstances, we have come to the conclusion that NCLAT was not justified in holding its order dated 28th August 2023 that the last tranche of 150 crores which was to be paid would be adjusted against the PBG. The SRA, having deposited the first 2 tranches of 100 crores, must comply with the remaining obligation of depositing 150 crores to make up a total payment of 350 crores. Having by it conduct accepted the terms set out by SBI, it must be obligated to comply with the entirety of the obligations. It must do so in strict compliance with the time schedule set out hereafter. The lenders have submitted, this is the first influencing. So please see 23. The lenders have submitted that the admitted claim of the financial creditors is 7,800 crores, while the package offered by the SRA in the resolution plan is 4,783 crores payable in a tranche of 5 years. Instead of infusing 350 crores being the first tranche payment, which was to be paid in 180 days, the SRA has infused a sum of 187 crores after 2 years, in addition to 13 crores paid by a third party. The lenders have already incurred
So the consequence envisaged under the resolution plan.
It fail. Then 33 will operate. You'll have to go for liquidation. And your lordship has said so in 25(1). That is consequence. It is not confined to affidavit. Just 2 more paragraphs I'll read it, my lord, so that it's clear. Please, 1 minute.
Appeal is directed against
Lord,
order
just can't
holding
do this.
compliance of condition
Lord,
precedent.
They can.
That's the only issue.
They can shout to any length. Lord, today
The question
there
of
is
shouting. My friend is angry all over.
Lord, somebody is taking the IBC process. Give me the time. It's a defining moment. Lord, it's enough of this. The lordship should say IBC is not, my lord, a law for abuse. It is it's a facilitator for a genuine takeover. Not, my lord, people can't, like these operators can't come and play with courts and abuse the law. I will show this, my lord. Lord, it's a responsibility. I make a statement, I'll make good. As a law officer, I will demonstrate the kind of abuse these people have been making. We have to put a full stop to this, my lord. Absolute violation. And your lordship should put it very firm in the judgment so that, my lord, this doesn't happen again and again. We should stop it. Please, my lord, please see 24. Please come to 23, your lordship saw. Then please come to 23 23 subpara 3. The lenders have already incurred 386.72 crores during the CIRP and after the approval of the plan towards maintaining the corporate debtor, excluding APO dues. In addition, the lenders are incurring 22.26 crores on a monthly basis towards expenses carrying costs for maintaining the corporate debtor. But please see 20. SBI has stated that the lenders have been saddled with huge recurring expenditure every month to maintain the remaining airline assets of the corporate debtor. The lenders have been embroiled in litigation before the NCLT and NCLAT with little progress on this ground towards implementation of the resolution plan. Such a state of affairs cannot be permitted to continue interminably, as it defeats the very objective and purpose of the provisions of the timelines under the IBC. The timely resolution of the insolvency cases is vital for sustaining the effectiveness and the credibility of the insolvency framework. Therefore, concerted efforts and decisive actions are imperative to break the deadlock and ensure that expeditious implementation of the resolution plan. This is the crux. This is defaulted in toto. It is not confined to 150 crores as they keep harping. The whole plan has failed. 25. The lenders have argued in the appeals that there has been a failure on the part of the SRA to comply with the condition precedent. If the SRA were to comply with the terms as envisaged in SBI's affidavit dated 16th August 2023, evidently issues pertaining to compliance with the condition precedents were not to be pressed thereafter. in order to furnish this SRA a final opportunity to comply and consistent with the above position, we issue the following directions. 1. Lord, please see it carefully. The SRA shall preemptorily on or before 31st January 2024 deposit an amount of rupees 150 crores into designated account of SBI, failing which consequences under the resolution plan shall follow, not affidavit. That's my friend. Keep on saying affidavit to law. This is what they argued before the NCLAT. Consequences under, because why? Because of 23 and 24. We can't be going on incurring costs like this.
Affidavit means your affidavit.
Yes.
But your affidavit also in the last line said it will be liquidated.
In continue resolution plan. Every other condition is...
No, you said liquidation.
Liquidation. Well, today it has to go for it. We'll demonstrate that. Please see, my lord, see the second condition. So one is, my lord, deposit cash. Please see condition 2.
KBG to continue.
To continue. And please see third. Whether or not SRA has been compliant with all conditions of the resolution plan as well as the conditions set out in para 8 of the affidavit shall be decided by NCLAT in the pending appeal. It disposes of everything in their favor.
Now the appeal itself has been decided.
Whole. That is why we are here. Lock, stock and barrel. But it says, for example, I'll just say one side. Well, the resolution plan clearly, very clearly says, upfront, your responsibility is to pay 475 crores as airport dues. Only then you'll get airport clearance. Now, they read, CARP cost is confined to 25 crores. Read, CARP cost of 25 crores as airport dues is a finding by NCLAT. Is it not perverse for us to say for this court to interfere? That's shocking. To the utmost respect, we say.
All right. Now, should we go to the NCLAT order?
We'll show one now that your lordship has seen.
Anyway, you are now showing us that RFRP clause 13, 3.30.
Yes. Two more things your lordship may note. After this order, they default. So there are 3 defaults your lordship may note. Time limit of 31st January not complied with.
1 second.
Yes. 3 defaults have happened. Yes. First milestone.
Just one clarification.
Yes.
Come back to this III.
Yes.
3 in para 25.
Should I read more?
1, 2 is crystal clear.
Yes.
Whether or not the SRA has been compliant with all the conditions of the RP, as well as of the conditions set out in paragraph 8 of the affidavit. The impugned order says that it has been compliant. Everything.
Clean. Clean shit. For example, this court has upheld a workman's compensation of 289 crores. They deal with 12 crores of PF and not a workman's compensation at all. And they say condition, everything has been compliant. And you should allow the plan to work.
But what does the impugned order say about condition number 1?
Condition number 1, it says, no, we can still adjust. But it reiterates this interim order. That is why I say there are 3 defaults. It simply reiterates you can adjust your PBG. When, my lord, we have shown it to the court. I will show only one clause. One clause of up to the plan.
She said 5 minutes.
Yes. Now, my lord, I will show one class. Your lordships, to answer your lordship's question, how it has reiterated the interim order. Please come to one page, my lord.
The convenience compilation?
In the same SLP book, 255. Yes. Your Lordship may come to page 240. 240. PDF 240, and then we'll go to this. Page 240.
Which is printed page 214.
Printed page 214. Please come to my lord, infusion and timelines. Please see what my lord, the order is.
This is the resolution plan, right?
It's a resolution plan. It starts from page 205. My Lordship may put only this one. How this 350 crores, how it has to be allocated. This is all part of the resolution plan.
Yes.
Please see, my lord, upfront within 180 days, 350 crores.
So that date, on which date this deadline expires?
Yes, my lord. Original effective date is, it starts from, my lord, 25/2022.
So 180 days from this date.
Date, of course, through our affidavit, we extended it up to even September 2023.
25/22
is the effective date. Well, this is very crucial. 25/2022, because they have conceded to this. They have agreed. The tribunal has passed an order agreeing to this effective date.
That's so 180 days expired on?
Well, 6 months from in November, which got extended twice. That is why, my lord, we filed an appeal and say we will not even contest those extension. So, my lord, we will say, even in terms of our affidavit, the last timeline expired on 30th September 2023, exactly 1 year before. Even if Lordship takes everything into consideration, no problem at the moment. Please take the extended time as 30/9/2023. In terms of our affidavit, it's still not, they need to bring 350 crores for this reason.
You have 200 crores today.
Only 200 crores.
150 was never brought.
PBG. But this is one. Now, my lord, what needs to be done in terms of PBG? Because that's a straight question. We'll go into the merit straight away. Please come to page 255 of the PDF. Because they keep on saying 150 can be adjusted. Adjustment is conditioned upon what? There are twin conditions. Both conditions are stands violated today and forever. We have no difficulty. We don't want to stand on any formality. We will go in whatever they want to. They are a defaulter. You want to go with the affidavit route, you are a defaulter. You want to go with the resolution plan route, you are still a defaulter. You want to go with the NCLAT route, you are still a defaulter because NCLAT gave time. But the final order passed in March gave them grace time. Still not complied. So, how long can we be allowing this to happen? You are a defaulter in terms of the resolution plan. You are a defaulter in terms of the affidavit. You are a defaulter in terms of the impugned order.
Every state there is an appeal.
No, you will appeal. This is where we have to put an end to this agony, and your lordship should pronounce. Lord, the people who bid for it can't take a court process to their advantage and keep the whole process choking.
What advantage?
Flights. There was a buyer to buy these flights. Now he's running away because he's finding, as year goes by, this is no longer a flight, it's a metal scrap. This is where they have brought us today. And lenders are made to beg and fight cases every day. They are court birds. Please see, my lord, what has happened in 255. Yes. Spent their term only in court, not in resolving the problem and allowing the flight to take off.
Have I taken away a plane?
Simple question. The investor has to have a security clearance, which he doesn't have from day one till date. We have got and applied a copy and put it on record. He doesn't have a security clearance from Home Ministry. This is the type of investor we have got it. They can't go on be giving running commentary. But the investor doesn't have a security clearance till date. Home Ministry has not cleared. To fly an airline, you need a security clearance. We have applied to the Home Ministry, got an official letter saying that so and so who is the investor doesn't have Home Ministry's clearance. Till date.
Last five
He's
submissions
facing-
are not on record.
He's facing-
The AST can't go on like this. Last five submissions,
But-
none of them are from the record.
Oh my God,
They're not from the record.
Everything
He's
is
just
not
saying it off the top of his head.
We
I've
are
got
used to
people to
this.
buy planes.
At least in this matter, I'm used to this because I had the same problem in NCLAT. I'm going to face the same problem.
And the
They
NCLAT
can
said
only-
so.
They can only raise
NCLAT
my-
devoted 10 pages on their conduct.
They can't raise contentions. They can
What
raise
advantage
only
have I
noise.
taken, my lord?
Seven-
I've spent 700.
More money is gone.
No.
I'm still struggling. What advantage have I taken?
Struggling.
Creating
Lord,
obstacles.
please prove. Lord,
This is what the NC.
Only now
so, Lord,
two
let me-
airlines
let
are
me
left in
prove
the
my
country.
case. Lord, I'm used to
Nothing
this.
else will survive.
Lord, I've come from a Muslim place, from a village. I'm used to all this. I have no difficulty. Any amount of noise I can withstand. And I can counterblast. Please don't take me lightly. I'm ready to. Please see, my lord. See, please see, my lord. Please see page 255. Don't take me lightly.
Why,
Page 255.
why did they say 700 crores?
Lord, you don't know from where. They have given us only 200 crores.
I'll show you from there.
Lord,
I'll show you from there.
Lord, we have got into our kitty only 200 crores, not a rupee more. And we are not saying anything beyond that. Lord, please, and we have incurred 500 crores so far. Lord, please see 250. Lord, yeah, we'll come to the merit stage.
Now, what you have to say?
Yes.
Summary of payments in security package.
Yes. Now, Lord, your lordship will see both the horizontal column and the vertical column. Please come to column 5. Date of creation of security. My lord has it.
Right.
And see, it says in all the columns effective date. And please note it, my lord. 25/2022. The lordship may make a note. For all. My lord has it.
Yes.
Yes. Now, for all the payments, your payments can come. See, first payment, my lord, first payment is 180 days. Second payment will be another 180 days. All that there is timeline. But your effective security has to be on the date. So, your lordship may first note what we said was this. Your effective date, which is 25/2022, obligating you to create mortgage of 3 Dubai properties of 100 crores each. And your lordship may now note the date. It starts at 25/2022. Now, NCLAT, through the impugned judgment, extends it, my lord, from March 2024 to 11/4/2024. Let's go by that. For a minute, it extended it till April 2024. Not a single property has been mortgaged. Not a single property. I will show the exchange of emails. Well, on 10th April, well, when 11th is the last date, 10th April, they come back and say, look here, how are you facilitating? Well, it is his property. And we have clearly said 2 crore 36 lakhs is what the service provider wants you to pay to get this mortgage. Immediately on 12th April, no, we don't have what that is going down in value. We'll give some property in Aligarh in India. And that is valued at this. Complete. This is something taking. So, please note 2 dates. 2 dates. It is a complete cock and bull story, Mullah. It's a fiction in every stage of the case. One minute. No, Mullah, whatever I say, I'll make good. Please note the date. Effective date is 25/2022.
Yes.
And extended by the impugned judgment till 11/4/2024. Lordship will say, please seek third column. He has to create mortgage of 3 properties. What are the properties?
Judgment to?
11/4/2024. Please see column 1, mortgage over Dubai, column 3, mortgage over Dubai property number 1 valued more than 100 crores. That is property 1. Then mortgage over Dubai property number 2 valued more than 100 crores is second property. 3.
That's the same property.
Same, different properties. Narration is given. Narration is given below. All the 3 properties, narration is given. And 3, my lord, mortgage over Dubai properties number 3 valued at more than 50 crores. It's not 300, it's 250 crores. I stand corrected. Then, my lord, if you do this, all the 3, on the effective date, then you can release your PBG. Please come to the last column. When can you adjust the PBG? To be released on the sale of BKC property, PBG can be adjusted year 5 and completion of payment, whichever is earlier. So, if you pay 108, Malad, you pay this.
I think the way it works is
Yes.
that the first horizontal column,
Yes.
it's mortgage over Dubai property number 1 valued at more than rupees 100 crores. Point, then thereafter, it is BKC property if given,
Yes.
or mortgage over Dubai property number 1 valued at more than 100 crores and plus mortgage over property number 2 at 100 crores.
Because they didn't give
In the third horizontal column is 100 crores, 200 crores, and then 50 crores.
50 crores.
That's
They
the way
didn't,
it
give,
works.
they didn't give BKC. So you have to give 250. They didn't give BKC. So on what? On the effective date. If you do this, if you pay 350 crores, create the mortgage, you release your PBG. No problem. Now the tribunal says in the interim order, reiterated in the final order, you can release your 150 crores towards tranche payment. We will give you extension of time for mortgage, which is also non-compliant today. They did two things. The tribunal, in short, will not dissolve. I don't have to read the whole order. Tribunal, yes, I'll show the findings in a minute. I will put it in writing also. Two findings the tribunal gives. Finding number 1, we will adjust, you are entitled to adjust your 150 crores towards your 350 crores.
Tribunal again says that.
Yes.
How could they have said that?
That is all.
It's a complete breach of discipline.
One. Two. When we argue, please see this effective date. He has to create a security before. Lord, how can we go without a security, Lord? It's simple, elementary. There's a statutory need that somebody has to give a security. So we said, how will you give a security? No, we'll extend time. So the tribunal says, you first adjust 150 crores. Order is passed. In the same order, time is granted by 1 more month. Till 11/4, you go and execute the bill. All right, let us accept it as a fact today. Today, my lord, we are in September 2024.
Should we see the tribunal order now?
Yes. Please see these two findings. I'll straight away, my lord. Yes, I'll give the findings of the tribunal. PDF page? Yeah, PDF. PDF page 118. Straight away, lordship may come to the tribunal's finding. Well, at PDF page 118, printed page 92. This will be and then I will show it.
What are you reading now?
Well, first I'll read the 150 crores adjustment, then I'll come to the Dubai property.
What page will that be?
Well, please see, will your lordship come to page, well, please come to 118. We'll go both together, one beneath the other. 118 PDF, printed page 92.
118.
118.
Page 92.
Yes. Yes, there. We have already noticed clause 6.4.4 under the heading Summary of Payments and Security Package. In clause 6.4.4, PBG of 47.5 crores, this stands now below 150, was mentioned. However, in the resolution plan, clause 6.4.2 was substituted, wherein additional PBG of 47 crores, PBG of 102 crores was provided for the effective date. Clause so and so. We'll read 100. Please come from 101. We'll read from 100. Please come from 103. Please come to 103. Straight away. 4 paragraphs.
Would my friend read from 100?
100? All right. I'll read 100.
From 100?
I'll read from 100. I have no difficulty. The SRA, the SRA within 7 days from 25/2022 had made balance payment totaling to 150 crores PBG. Very good. There is no dispute that 150 crore PBG has been provided by the SRA within the time frame prescribed. Yes. There is dispute between the parties regarding creating mortgage over Dubai Property 1, Dubai Property 2, Dubai Property 3, which was contemplated in clause 6.4.4. The learned counsel for the appellant submitted for creating mortgage. An application was made by the SBI lead creditor to the RBI for creation of security on 24/2/2022, and RBI by its order dated 22/7/2022 has already approved the creation of mortgage on balance security of Dubai properties. So we have obtained the clearance. The appellant, having taken the stand that effective date has not achieved since the SRA has not completed the condition precedents, did not move forward for creation of mortgage over the Dubai properties. Immediately after order dated 13/1/2023 passed by the adjudicating authority, holding that SRA had completed the condition precedents, SRA sent reminders to lenders seeking approval and signing of transaction documents for creation of security. The lenders did not respond nor provided their, leave it, let's read everything. On 3/10/2023, SRA again sent mail to MC lenders. MC lenders have recently on 19/1/2024 engaged one valuer, value start to conduct valuation of the properties. Now please come 103. We noticed that in the resolution plan class itself, 6.4.4 provided that secure, I'm sorry. Show them. Yeah. May I read?
Accepted the conditions precedent have been met. Today.
Please come to 103. Malad, after I read these two paragraphs, I will show the exchange of email. That's very important because the kind of, Malad, this is a real test. You just choke, keep writing, keep dumping things, ask us to reply, and keep on telling the court we are fighting amongst each other, and then start blaming. I'll demonstrate how this has happened in this Dubai property. Please come to 103. We notice that in the resolution plan itself, clause 6.4.4 provided that security will be created at the cost of the resolution applicant. Thus, it is resolution applicant who has to bear all costs for charge creation. The mortgage bar charge over Dubai properties is essential condition of the plan for proceeding further. We are of the view that ends of justice will be met by issuing appropriate direction to the lenders to take all steps for creation of charge and direction to SRA to bear all expenses. We direct that the said proper process of creation of charge of Dubai property 1, 2, 3 be completed within period of 30 days. Not two errors we straight away point in 103. But it is their property. Why should we bear the expenses? Where does the resolution plan say? It is their property to create. We have indicated that the surveyor valuer wants 2.36 crores for you to register these properties. We have indicated the amount. Two, my lord. Two. These three properties, please.
They directed the SRA to bear all expenses.
Yes, the SRA has to incur.
So, Lord, for 2 years, that's why I said.
Lord, I'll solve that. Lord, please.
I will bear 100.
Lord,
for
any
2 years,
I am ready.
They said we will not.
Lord,
the problem is this.
Mr. Lord, 100 times I am ready to read it. 100, not once. 100 para, 100 times will read it. It's not going to improve their case.
Para 100 shows that for 2 years, they did not accept it. They don't accept till today that effective date of the condition precedent is May 22. They never accepted. Today, my friend says date is fixed. Even today, they are in appeal before NCLAT. The condition precedents have not been met.
And
if you are a stumbling block at the condition precedent, the security doesn't work because you don't want to move forward. And against the order of NCLAT, even now you are saying condition precedent is not met. How is my friend saying it's an agreed date? I was shouting hoarse. May 22 is the date fixed. He said, I don't accept it. I will go and appeal. I will apply for stay. That's why all interlocutory appeals came here.
No stay is granted. But
that's all right.
One minute.
So how can I, my lord, proceed?
Why?
After April 22,
why not?
Fighting
Why
at every stage.
And
now you put the blame on me.
It is their case. It is their case. Condition precedent has been complied. What is your problem? Throw it in your face. Look here. Take this Dubai property. Take this 350 crores. Give us the key. We'll start running. Why did you not?
The problem is
your airport. Show me your for the last several years they don't have an airport permit. For the several years they don't have a clearance for foreign airlines. But every condition of the resolution plan they are a default. Sorry,
the conditions.
But any amount of noise, I will give a matching noise and also put my case. I don't have a problem. I can do both simultaneously. Can't take on. .
103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 103. 1
It's concept.
It's being created until.
At all, even today, and I will show the exchange of mails. But this order is passed on 12th March. Lot you may note the date. 12th March 2024 is the impugned order, judgment, or the enclad. And it gives 30 days.
So what is pending today before enclave?
Everything has been given, transferred here, saying that your resolution plan is clean, you will comply with all this and you hand over, is what they are saying.
Hand over
Huh. When, my lord, I will show default after default. Give me just little time. Now that this is the major matter, rest is all just hardly 5 minutes. I have to show the resolution plan, class, and say how they are a defaulter in each one of them. But please see, two more, before that, Lordship, the Lordship will mark it saying that they are a defaulter, execution has not happened today. I will show only 2 mails in exchange of mails. Then I'll finish this 150 crores PBG also and then show the mails. Lord, please come to next page, para 104. That is for the, there are 2 conditions. 150 crores should be adjusted according to us only when you create the Dubai properties. Now see what the tribunal does. Yes. Please come to page 1, para 104. As noted above, the SRA has already paid an amount of 100 crores on 31/8 and 100 crores on 39, and 150 crores was not infused by the SRA as per the offer given by the affidavit by the appellant. An Honorable Supreme Court has already held by its order dated 8/1/2024 that the SRA having not infused 150 crores, it is not entitled to take the benefit of affidavit dated. How do we say? Your Lordship has said the consequences of the resolution plan will follow. Now it is substituted saying benefit of affidavit. It's the first finding. Second, we have already held SRA is not entitled for the benefit of affidavit having not infused. The question now to be considered is as to whether appellant is entitled to adjust 150 crores PBG which is lying with SRA towards first tranche payment. We may refer to the summary of payments which your Lordship saw. Please. Not your Lordship saw the summary. Please come to 107. The above clause clearly indicates that in the first tranche payment under the heading date of release of security, the expression used is PBG adjusted. Thus, resolution plan clearly contemplated that in the first tranche payment of 150 crores, PBG should be adjusted, which was a clause of the resolution plan duly approved by the lenders. We are thus of the view SRA having already paid 200 crores, the amount of 150 crores which is lying with MC lenders as PBG is to be adjusted in the first tranche payment for completing the payment of 150 crores. Thus it is held SRA has completed the first tranche payment of 350 crores. Please see, my lord, overlooking the entire column on effective date. And, my lord, and the creation of the mortgage. Column 3 says you have to create mortgage. Column 5 says on a particular day. If you do these, then adjust. Now 3 is left out, 5 is left out, you adjust. So there are 2, in the first issue, there are 2 findings. 107 proactively allows adjustment. It is nothing but reiterating an interim order in spite of your Lordship's decision on 18/1/2024 and the dismissal on 2/2/2024. They filed an extension. 2 of your Lordship's orders, this para 107 is in complete contradiction to what your Lordships have passed on 18/1/2024 and 2/2/2024 and the resolution plan. One. The second point is, my lord, paragraph 103, allowing 30 days time to create security in Dubai property. They continue to be a defaulter even today, even according to the order. Let's rewrite everything. 103 says, give it within 30 days. The 3 dates are important. The judgment gets passed on 12/3/2024 and they sleep for 29 days. That's very critical. No action till 10th April 2024. They keep speaking good conduct as though, my lord, we are trying to damn them. 29 days, total silence. Then, my lord, On 10th April, they shoot a mail. Page 189, my lord, it's 194 PDF. This is of additional set.
Of additional.
Additional set, 194 PDF. Well, they write to us on 10th, which we reply immediately. On 10th April, they write to us. I don't want to read the whole mail. Please see come to paragraph 3, middle portion. However, considering the strict timelines, about 5 lines from the bottom, para 3. Yes. My lord, para 3. Yes. However, considering the strict timelines provided for plan implementation, the SRA has no objection with MCR lenders immediately proceeding with security creation of Dubai properties as envisaged in the resolution plan at the cost of SRA in the form and manner in which MC lenders and their counsels are satisfied. As previously informed, the SRA is willing to execute any security documentations which satisfies the lenders and their counsels for such security creation. With respect to the latest valuation of Dubai property carried out by the MC lenders being so-and-so, 236 crores, SRA is exploring the 2 options suggested by MC lenders in the last meeting.
Who's this email by?
My lord, by them to us.
Yes.
Yes, by them to us. So, my lord, they shoot it on the 29th day. Now, and they say that there is a shortfall of 14 crores which they will manage in Indian property. They say 14 crores, last line, my lord. If and when SRA is able to provide alternative immovable property as security in India to the satisfaction of MC lenders, the said new security can replace the Dubai property subsequently, all that. Immediately, my lord, please see, next page, they also say, yes, please see, my lord, we had transferred rupees 20 crore in Jet Airways account as intercompany deposit, out of which 76.07 lakhs is already available in account number so-and-so maintained by SBI. So 76.07 lakhs is the pending amount of the 20 crores. Please see our mail. Immediately on the same day, PDF page 196, we reply. We didn't want to wait. Please come to my lord. As per the order dated 12/3/2024, you are directed by the NCLAT to take steps for creation of charge over the Dubai properties within 30 days.
What is the date of your mail?
Same day.
Right.
Same day. I'll give the timing, my lord. Ours is evening 7:18. Their mail is, my lord. First mail is evening 4:38. Second mail is evening 5:18. And our mail is 7:18 evening. Within 2 hours, we reply. You are aware that the assenting financial creditors via this meeting dated 13th October 2023 have appointed Master Bank to act as an agent for creation of mortgage in terms of prevailing law in Dubai. We note that we are yet to receive necessary amount which is required for payment to the bank. In the 36th MCA meeting dated so-and-so and 37 all that narration. Third, instead of remitting the amount for creation of security, as already advised to you from time to time, you have today sent an email stating that you have no objection with MC lenders immediately proceeding with security creation of the Dubai properties. Honorable NCLAT in its order dated 12/3/2024 has categorically held that cost for creation of mortgage of properties is to be borne by the SRA. Despite the above referred correspondence and minutes of the meeting, you have not remitted the amount towards creation of the securities. Instead, the lenders are now being asked to proceed with security creation. Please also note that account number so-and-so of remitting required amount has already been given to you by email dated. A separate mail has been received by the lender at 5:18, wherein you have stated that an amount of 76.067 lakhs, which is lying in the intercompany deposit, be used for the purpose of cost of creation of mortgage. In this context, please note that first of all, that today is the last date for creating the mortgage, and further as already advised, The cost towards creation is 2 crore 36 lakhs and not 76 lakhs. Further, in the second MC meeting, it was pointed out there is a shortfall in the value of the Dubai properties and NSRA sought to uphold property in India as a security for the shortfall. The concrete offer of the SRA in this regard is still awaited. The lenders are to be compensated by today towards shortfall in valuation of properties at Dubai by equal in value of 14, cash payment of 14 crores in compliance with the approved plan and orders passed by NCLAT. It is wrong and totally denied that SRA received official communication from MC members to explore immovable properties in India only last week, as alleged by you in today's mail. This statement is totally contrary to the minutes in the event. Now, please see the next mail on same 10th April at 9 o'clock. Not at 4 o'clock, they are talking about Dubai property. At 9 o'clock, see what they write to us. Please see, attach the title deeds for 12 acres of contiguous land situated in Aligarh, Uttar Pradesh, which is currently valued in excess of 250 crores and is owned by a reputed individual entrepreneur resident in India. He is a third party. The SRA can offer the said property to MC lenders as alternative security in India. Midnight. It is expiring on 11th. They are writing on 10th. Then what we immediately reply on 16th. Please see, my lord. Next page, without prejudice. At the outset, please note by its order dated 12/3/2024, Honorable NCLAT had given you further 30 days from date of this order, thereby directing you to take steps for creation of charge over Dubai properties, by directing to bear all the necessary expenses for creation. This period of 30 days has already expired on 11/4/2024. Further, by email dated 10/4/2024, you have already been advised that you are in default in as much as amount for expenses for creation of charge over Dubai properties have not been paid by you. It seems that in order to cover up your lapse, you have sent the trailing mail. You are aware that the parties are bound by the resolution plan. As per the plan, you are required to create securities by way of creation of charge over the 3 properties in Dubai. You had advised that as the value of 3 Dubai properties has come down to meet the shortfall, you had suggested providing additional security in India. The lenders have not agreed at any stage that properties in India would be taken as security in lieu of the 3 Dubai properties. We further state, under the plan, the 3 Dubai properties belong to so and so, so and so, and so and so, so and so. Further, the lenders took step by seeking clearance from RBI in this regard and consequently arranged for the same. However, as per your trailing email, the property...
There's no...
Absolutely. So, my lord, the first default, your lordship may note, 3 points, my lord. Your lordship's order not complied.
Yes. Slowly.
First point, my lord, on 150 crores adjustment, we have 3 submissions to make. The impugned order is in violation of your lordship's judgment 18/1/2024 and 2/2/2024.
Yes.
2, without prejudice. Now, their case will be, it only affidavit goes, we can argue resolution plan. So, without prejudice, we'll put a without prejudice point. Assuming, my lord, they have a chance to argue before NCLAT, the finding by the NCLAT, again reiterating the interim order of adjusting 150 crores PBG is, my lord, legally incorrect. Contrary to the explicit resolution plan. This out without prejudice, my lord. Assuming they say this condition before the Supreme Court was only for affidavit. Therefore, we have entitled to, okay, you go and argue. Having argued, the finding saying that you can still adjust, my lord, is second. Third, my lord, they are well aware, the tribunal, my lord, is cognizant of the fact that creation of securities is mandatory for release of the PBG. It swaps the whole condition. It says, first we will adjust 150 crores and gives 30 days time to create security. Completely ulta. It's changing the resolution plan. Resolution plan says creation of security first, then PBG adjustment later. Whereas here, PBG adjustment first, creation of security later. And today, even today, my lord, securities have not been created. Yes. We'll straight away go to the next point. So, therefore, my lord, your 150 crores PBG adjustment, even according to the tribunal's own finding, has to fall. Well, please come to, my lord, page 234, second issue. 470, my lord, one is 150 crores, first issue is over. Second is upfront default in payment of 475 crores of airport dues. How will this plan work? Civil appeal 234.
The additional diary?
No. Now your lordship may come to civil appeal. We'll put a small note without putting the page numbers very clearly.
Yes.
Yes. We'll just rush to the rest is all very, very simple. So this is the main issue. Now please come to the second important point is the resolution plan obligates them to pay upfront airport dues of 475 crores, which they have not done. Please see, my lord, the condition. We'll show in the resolution plan, my lord, page 234 of the civil appeal paperwork. Yeah. 234, my lord, printed page 208. Please come to the dotted point, my lord. BKC property not part of the resolution. My lord has that column.
208, right? 208,
printed page. So, my lord, BKC has never formed part of the resolution plan, so we'll ignore that. Please come 4 lines down. Put 234 PDF. Further, then the airport dues. My lord has it.
Where do you get that?
My lord, BKC property not part of resolution.
Yes.
Your lordship has that column?
Yes.
Yes, sir. So, 4 lines down, my lord has it?
Yes, further then.
Yes. Further then, the airport dues and parking charges after the ICD. Lord, please note, approximately 240 crores as on 31st August 2020 will be paid by the resolution applicant upfront in priority over any other payment to the creditors of the corporate debtor subject to the maximum of 475 crores. Today it is 1,200 crores or 1,100 crores because every day they are defaulting for the past 4 years. So it says upfront maximum 475. Why? As per the general aviation practice, in respect to parking and airport space, as and when corporate debtor will intend to use or move the aircraft or use the airport space, such claimants will seek their past dues. Therefore, the payments need to be resolved upfront by pro rata reduction of the amounts payable to the other creditors to enable the corporate debtor to recommence its operations, which is why the resolution applicant has suggested that their payments be made upfront against the BKC. Such payments will be settled upfront in full in first 180 days from the effective date and without any conditions, including not being staggered payments spread across a period of time, so that flying can start immediately without any future disputes and concerns with such claimants for the past dues. 475. This is further vindicated, my lord. Please see at my lord 242. Same resolution plan. Treatment of the stakeholders. Yeah. 6.4. We'll show just 4 clauses and see, my lord, how the tribunal has rendered its finding. 2 minutes, I'll just read the finding. That's all. This issue is over. Please come to, my lord, 6.1.4a. In terms of 32A of the IBC, the CIRP cost ought to be paid in priority to any other creditor of corporate debtor. B. As per the information disclosed by the resolution professional on 14th August, the CIRP cost includes operating cost 27.6 crores as on August 31st, 2020, which includes fees, charges, salaries of asset protection team of the corporate debtor and other costs incurred by the resolution professional in running the operation of the corporate debtor as a going concern. It nowhere says airport dues. Now, my lord, please come to F. The resolution professional has estimated an approximate sum of 240 crores towards parking charges for aircrafts and airport space lease charges. Such amounts are good faith estimates of the resolution professional based on previous invoices, as it has not received any invoice but demand from any other lessors or owner for such amounts. The resolution applicant shall endeavor to negotiate the parking fee and rental fee for the corporate debtor within various airports and will endeavor that the cost for such heads is kept to the minimum. Then what H? Please see H. This is the clause which the tribunal is relying upon to say it is restricted to 25 crores. This is the clause. Please see H. Based on the information provided, the resolution applicant have assumed that the amount standing to the credit of the bank account of the corporate debtor, including amounts estimated to receive subsequently, are sufficient to cover for the CIRP cost of the corporate debtor, excluding parking charges, rental charges, employee dues, taxes, etc. Excluding. The tribunal reads it as including. And what is the amount fixed? The resolution applicant has set aside a sum of 25 crores as CIRP costs towards payment of any such cost until the approval date. Then please see J. It can't be more clearer than this. The resolution applicant states, if the CIRP cost is less than the estimated amounts and the airport dues are less than 245 crores, then the differential amount will be paid to the resolution applicant to the assenting financial creditors, which amounts are over and above the amounts received from them with the resolution plan. They deal CIRP costs independently, they deal the airport dues separately, and says if it's going to be both or less, it is 20 crores and it's 100 crores, please pay to the assenting financial creditor. So, my lord, when this is so, please see the finding. Please come to, my lord, page 78 of the, my lord, tribunal. Paragraph 51, paragraph 52. We'll read 51 also, there's submission also.
Yes.
Yes, not two paragraphs, paragraph 51 and 52. On the submissions raised by so-and-so, SRA having not paid airport charges, slot allotment cannot be made to be complied. It is submitted that it was the obligation of the SRA to pay airport charges which has not been paid. The SRA had not complied with the obligation. So-and-so refuting the submissions of the learned submits, airport charges have to be paid as per the resolution plan as a CIRP cost by taking into consideration the positive bank balance and also deduction from share of the dissenting financial creditors. He has referred to the relevant clauses. Please come to 52. What is the relevant clause, my lord? Priority of payment 64 6.4.1.m is as follows. CIRP costs shall be fully paid and discharged after the effective date before the payment is made to any creditors as per the resolution plan. The resolution applicant will be entitled and will use funds available with the corporate debtor on the effective date for making any portion of the CIRP payments. 6.4.1h. We have read to your lordship's blood. Please see, it extracts clause H without any difficulty. Please see within the bracket, excluding parking charges, rental charges, employees' dues and taxes, etc. That's the extract. And please see the finding in 54. The provisions of the resolution plan as noted above clearly indicates CIRP cost includes airport charges. SRA is also entitled to use funds available with the corporate debtor as on effective date to meet any portion of the CIRP cost. The submissions the appellant that the entire airport charges have to be borne by SRA upfront cannot be accepted, nor non-payment of airport charges by SRA as on date makes the allotment of slots unavailable to the SRA. Allotment of slots having been achieved by the SRA as noted above, non-payment of airport charges upfront by SRA cannot be said to be a reason to not accept the fulfillment of condition of slot allotment. The payment of airport charges has to be made as per the resolution plan when the implementation of the plan commenced as per the resolution plan. We thus do find no substance in the council. We regard... Go to contingent precedent. Go. So, my lord, please make a note. The second default is 475 crores of airport dues.
Yes.
Now we will show the third default, 289 crores of workman compensation. And then finally, all the 5 condition precedents stands violated. For example, this finding says in para 53 and 54, you don't have to pay 475 crores, only 25 crores of CIRP, and therefore your slot allotment stands revoked. Nobody has given, the airport authority has not given any slots to them. A ruling says slot allotment stands complied with. Where is the slot allotment? Please show to us. This is what we are asking. So this is how. So third is please come to workman compensation. Please come to 425. Okay. 425 is the order passed by the NCLAT. Order is dated, my lord, 21st October 2022. 21st October 2022. 21st October 2022. My lords may come to PDF page 510. Paragraph 80. Before that. 289 crores. Yes, ma'am. Will your lordships come to 510? The top. Lord, it quantifies both PF and gratuity. And Lord fixes it at the lordship will see the provident fund, leaves, and gratuity. Total amount is brought 289.2 crores. My lord has it.
Yes.
510. Lord, this is it. Our submission is going to be the impugned judgment is not only in contradiction to violation of your lordship's order upholding this, it violates its own NCLAT order. Now, there are 2 violations, my lord. It goes in contradiction to your lordship upholding the order and it violates this very order. Please come to 510. My lord, what is decided by the NCLAT in its order dated 21/10/2022 is workman's dues should be 289.2 crores. And my lord, please see para 80. As observed above, in admitted claim of workman provident fund, gratuity and leave encashment was included and payment proposed in plan partly satisfy above dues also. The workmen are entitled to full payment of provident fund and gratuity. Hence, the balance of above dues ought to be paid by the successful resolution applicant to satisfy statutory obligation. Now, please mark, non-payment of full provident fund and gratuity shall lead to the violation of section 32E. Hence, to save the plan, the above payments have to be made. Lord, this is the finding. This is upheld by your lordships on 31/20/23. Lord, PDF page 698.
Yes.
We find no error in the order of the National Company Law Appellate Tribunal dated 21st October 2022, read with its clarification order dated 2nd December 2022 in companies of these appeals are accordingly dismissed.
Now,
Yes. Now, my lord, please come to the finding. Impugned judgment, my lord. Page 123, paragraph 113. Page 123, my lord. It starts at 123 at 125. It starts at 123, paragraph 111, workman and employees' dues, and the final finding, my lord, para 113 and 114. May I read these 2 paragraphs, 113 and the next is condition precedent. With my case is over. I had to show only condition precedent breach and over. 113. When we look into the above directions, it is clear that the amount to be paid by the SRA towards Provident Fund and gratuity was the amount to be paid after adjustment of the amounts received under the plan. The above clearly indicate that the amount is to be received by the workmen and employees under the plan first, and thereafter the amount has to be paid as per the order dated 21/10/2022 regarding full Provident Fund and gratuity. We have already noticed above the Learned Counsel for the SRA had undertaken that in so far as the payment of Provident Fund to workmen and employees under order dated 21/10/2022 amounting to 12 crores is concerned, the same shall be paid upfront along with the payment under the plan. The SRA has undertaken to make the aforesaid additional payment along with payments under the plan. The IA so and so. Several prayers have been made by the association of the agreed workmen of Jet Airways. The applicant were permitted to intervene in the matter in this appeal, which is an appeal against the orders that passed in the authority on 31/3/2023 by the lenders. The issues between the lenders and the SRA regarding completion of the condition precedent. However, this tribunal has not noted all that it says. Where is not the balance payment of 275 crores? Provident Fund. Gratuity. Only Provident Fund of 12 crores. And gratuity goes. So, my lord, the third one minute. Yes, in fact, come to the last paragraph 129 at 133. So, because the number is very clear there. Waterfall mechanism. But 133, please come to clause 8. Towards payment of provident from dues as per the order dated 21/10/2022 passed by this tribunal in company appeal so and so, SRA has undertaken to make payment of provident fund upfront along with payment of dues of workmen as per the resolution plan, which payment of 12 crores as undertaking shall be made in addition to the payments as there. Only 12 crores. And my lord, under 53, my lord, there is a statutory mandate. Under the waterfall mechanism of 53, my lord, they stand a priority. Yeah. Even as per plan. Lord, we'll reiterate 4 numbers now to your lordships. Lord, please see 150 crore on first tranche, 475 crores on airport dues.
1 second.
Yes. Yes. A unilateral adjustment of PBG to the extent of 150 crores.
Repeat it again. 150
crores relates to adjustment of the PBG. Non-payment of airport dues is 475 crores upfront. And 3, workman dues of 289 crores. But these 3 add up to a value of 914 crores today. Plus, 250 crore of mortgage property. And adding this value, it is today, my lord, the number is 1,164 crores. Not 150 crores. The last one is the condition precedents. Now, please see 286. 286 are the same resolution plan. Yes. 286 below. Please come to 7.6 conditions to the implementation of resolution plan. 7.6.1 condition precedent. The obligation of the resolution applicant to recommence operations as an aviation company, being the business proposed to be acquired, is subject to the fulfillment of the following conditions after the approval date. Condition precedent. Now, please see, we are only today A, C, and D. These three is enough. And demerger and all. Okay. A. Validation of an air operations certificate of the corporate debtor by DGCA and MOCA. The AOP of the corporate debtor shall have been validated by the DGCA, the MOCA, and any other relevant government authority, and grant of all other mandatory approvals to the corporate debtor to enable it to recommence flying operations, including commercial or cargo operations and related on-ground services. So you should have, my lord, an air operation certificate for all times to come. Now, my lord, please see the finding. See, my lord, we read the other two conditions also. See, slot allotment approval. The DGCA and Ministry of Civil Aviation shall have approved the reinstatement of all the suspended slots, including the bilateral rights and traffic rights, back to Jet Airways by the corporate debtor. The slots, along with the related bilateral rights and traffic rights, can be allotted to the corporate debtor gradually as per its business plan, with immediate slots allotment approval along with related bilateral rights and traffic rights for sectors on which Jet Airways so and so. Then D. International traffic right clearances. The corporate debtor shall have received the international traffic right clearances in compliance with the applicable laws. These are condition precedents. Then please come to 7.6.2. The date of fulfillment of all the condition precedents as stated in 7.6.1 above shall be the effective date for the purpose of this resolution plan. Therefore, my friends keep saying we are all fighting, so matter is not resolved. So endlessly we can postpone the effective date. When, my lord, the tribunal fixes the effective date as 25/2022 to say, NCLT says two things. Your effective date is 20th May 2022 and all these conditions stands complied with. Even today, they don't have an air operation certificate. Expired, never renewed. Never ever renewed. Where is the fight for you to renew it? And
It will never be renewed.
my lord, please.
No slots allotment.
Not all.
Oh my God, I had 48 slots.
Oh, my lord, all
Every fact is wrong.
Oh.
I had 48 slots. I had air operators.
He will have all his
They will not. They kept a stumbling block at every stage.
I'm hearing for the nth time.
I've heard him say again and again, my lord, the chief judge said, you don't have slots? I had 48 slots, my lord.
Show, please.
I can't go on having slots for 10 years if I don't have an aircraft to fly. I can't have an airport without aircraft certificate, which I had for 1 year. I can't have it repeatedly at Juhu in Bombay airport when the planes are just standing like junk.
Well, why?
What's the point of getting, you can't get an approval or a renewal when you are not able to take off?
Who is, my lord, this let me sing with him. This 48 slots is subject to his clearing airport dues of 475 crores.
Correct.
And now
the airport dues had to come from the cash kitty of this company, which is 400 crores, which is under their control.
But everything has to come from the.
He doesn't give me the key.
You want
that 400 crores, blood.
You want.
I get that slot. Say you pay. I'm not going to pay. I don't accept your conditional precedent. I don't accept the date of 20th May. I will not lift a little finger to cooperate with you.
So,
and there are at least 10 appeals filed only by SPI. They have brought down.
Why?
They have brought down Air India.
You bring nothing.
They brought down Kingfisher. Today we have 2 airlines left. If this is the attitude, no IBC will ever work. And I am down 700 crores. My friend says, I have taken advantage. What advantage have I taken?
But I'm surprised at the lung power that they still want to say IBC will work in this case. I'm really surprised. I'm shocked.
On their
I'm shocked at this stage.
by Justice
But let me close this case.
He has not read those.
If my friend,
5 minutes now, you can wind up.
that's all, wind up. Please, my lord,
Madam.
yeah, these three things. Please see, my lord, an air operation. Please come to, we'll come to the finding. My lord, will your lordship see, this is the 8, please come to first, my lord, page 842, then I'll show the finding. 842 of the same compilation, PDF page. This has to go for liquidation, my lord. There's just no choice. Enough is enough. And your lordship should be very firm about, they can't play with law, they can't play with courts, and continue to say that I will do whatever I like, and you are postponing my day, my compliance day. Now, please see 842. This is their readiness. Sorry, 842. Or should I, in case, should I continue on Tuesday? I'll continue. I need another half an hour just to show this.
Oh, you wanted 5 minutes.
No, no.
We'll then continue on Tuesday.
Tuesday, I'll complete with this.
Tuesday will be first on board.
First on board, and we'll complete it.
Yes, but I want to complete it on Tuesday. Lordship will spend enough time.
Which matter?
OBC matter. We are seeking, presently, we are paying for an interim relief because all those caste certificates have been declared invalid. Could it be tomorrow?
Your lordship,
Tuesday first time.
Because this bench, this combination is God. They just throw up us as a
Your lordship, item 16 be continued next Tuesday, your lordship, the board which is listed. It's a Vanashakti matter, your lordship.
Yeah, but these matters are continuing because they will not go down. Anything which will be added at the bottom.
That's right.
Grateful, sir. Great.
Deeply obliged.